We're now on a record. My name is Mark Onkley, the videographer. This video deposition is being heard before the United States Bankruptcy Court, Eastern District of Louisiana. Today is July 2nd, 2024. The time is approximately 8:59 a.m. Today's deposition is being held at 201 St. Charles Avenue on the 52nd floor in New Orleans, Louisiana. Taken in a matter of the Roman Catholic Church of the Archdiocese of New Orleans. Today's deponent is Mr. Lloyd E. Eagan, Jr. Today's court reporter is Ashley Onkley. I would ask that counsel state their names for the record, which thereafter would the court reporter please swear in a witness.
I'm Richard Trahant for certain sexual abuse survivors.
Soren Giselson on behalf of the movers.
Patrick Vance on behalf of the Archdiocese.
Mark Vance on behalf of the Archdiocese.
Okay. Sir, would you raise your right hand, please? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So
Yes, ma'am.
Good morning, Mr. Eagan. I'm Richard Trahant. Probably the most important thing I have to tell you here is if you need a break and it looks like you could tend to become uncomfortable, simply let me know. If you need to use the bathroom, if you need a break for anything, with the exception of if there is a question tendered, I would appreciate you answer the question before you ask for a break. All good?
Yes, sir.
All right. Can you tell me, Mr. Eagan, everything that you did in order to prepare for today's deposition?
I wrote a series of bullet points and reviewed them with counsel
When did you write those bullet points?
last week.
Do you have those with you today?
No,
Why not?
I didn't bring them.
Why not?
I didn't want to.
Why not?
I gave you the answer. I didn't want to.
All right. But you're not going to tell me why you didn't want to bring your bullet points.
I don't need them. I have them up here.
So you can prepare a document and remember what it says without referring to the document.
It's only 2 pages.
All right. But you have to answer my question.
Yes.
Okay. Aside from the document you created with the bullet points, what other documents did you review in order to testify here today?
The petition,
What petition?
is that what we call it when what you all filed? I reviewed that.
The objection to the 11th interim billing application?
Correct.
Okay. That's it?
That's it.
Have you watched any videos on how to give a deposition?
I've given depositions in the past.
All right.
No.
Okay. Relative to today's deposition, what lawyers have you consulted with?
Pat Vance, Mark Mintz.
That's it?
That's it.
How long would you say you spent in preparation for today's deposition?
2 or 3 hours.
And when did you do that?
Last week.
And who was there?
Pat Vance, Mark Mintz.
All right. So as it relates to your preparation for today's deposition, did you consult with anyone other than attorneys?
No.
Did you talk to the Archdiocese General Counsel, Susan Zarang, about your deposition?
No.
Why not?
I didn't feel it was necessary.
You didn't feel it was, I want to be clear on this, you didn't feel it was necessary to speak at all to the General Counsel for the debtor before giving a deposition?
She does not review the invoices, so no.
Okay. She doesn't review them at all?
No.
All right. Why?
I set the barrier up early on that there be a distinction and she not review them. The Finance Council and the Archbishop delegated that task to me.
Why are the billing statements addressed to her?
Cannot answer that. I do not know.
Do you know who set it up such that the billing statements are addressed to her?
I do not know that.
Okay, and so certainly before today and before me asking this series of questions, Mr. Eagan, you knew that all 11 interim fee applications were mailed directly to Susan Zarang, correct?
No, I do not know that.
All right. Are you learning that today?
No,
All right.
they were not mailed.
How did she receive them?
She does not. She never sees them.
Her name is on them, correct?
She does not see them.
Okay. I understand, and it's fair. You can elaborate on any question, but if I ask you a yes or no question, I would appreciate you answering yes or no, then explain as much as you care to. Understood?
Yes,
So they are directed to her, they're addressed to her, correct?
addressed to her.
All right. And so is it your testimony, not only does she not review them, she doesn't even get them at all?
That is correct.
All right. And so if I'm understanding your testimony correctly, Mr. Eagan, the general counsel for the debtor, this debtor, never looks at attorney billing fee statements.
She does not look at any of the bankruptcy billing statements.
What does she look at?
Dentist show bills, ordinary course professionals.
What about committee fees?
No,
What about expert fees for those retained by the committees?
no.
Why doesn't she look at any of this stuff?
It has been set up that I download those fees. She does not see them, nor are they mailed.
Why has it been set up that way?
I decided through the through the Finance Council and the Archbishop's directive to do it that way.
Okay. Why did the Archbishop give you that directive?
You'd have to ask him. I do not know.
All right. And so if I want to know why his general counsel is not looking at any of the attorney's fees in this bankruptcy, you would agree with me that I have to ask Archbishop Amon that?
No, you would ask me.
Okay. Sir, didn't you just tell me when I asked you why he gave you that directive that you didn't know and I would have to ask him?
The Finance Council recommended to the Archbishop that there be a Chinese wall, essentially, between the General Counsel and the fees for Jones Walker and all professional fees.
Are you on the Finance Council?
I am,
And so you made that recommendation.
yes.
Why?
I thought it was the appropriate thing to do
Why?
because it's a business issue and not a legal issue. The experts are business experts, and I want to review every line.
So what you're telling me is that you believe legal billing statements are not a legal issue.
I am saying to you that we set up a structure and process whereby I review all bills relative to the bankruptcy and not the General Counsel.
Well, and I'm not trying to be argumentative with you, I'm really not. But I want to know the why of that. Certainly, if I were the general counsel for an organization, I would definitely want to see the legal bills. And so I'm trying to figure out, have you ever determined why she doesn't want to see the legal bills?
It was not her decision. I shared with you it was a recommendation by the Finance Council, of which I'm on, to the bishop that she not see the bills, that it be approved by me, and I report back to the Finance Council.
All right. And so all of these fee applications are filed into the record, correct?
Fee statements or applications?
The fee applications.
Yes.
And she sees them, right?
I can't tell you what she sees if it's filed in the record.
All right. So everybody who is on the bankruptcy PACER system has access to these fee applications. You would agree with that?
Yes.
And certainly Ms. Zarang is one of the recipients of those fee applications, correct?
She has access to review them if it's filed in the record, yes.
And are you sitting here, sir, 4 years into this bankruptcy, telling me you don't even know whether she looks at those once they're filed or not?
No, I do not know.
In preparation for your deposition, did you have any mock or practice sessions?
No.
Is there anyone attending this deposition by telephone?
Not that I'm aware of.
Are you currently on the boards of any of the apostolates?
No.
Do you attend any board meetings of any of the apostolates?
I'm an advisor to the cemetery board because of my family's history. The captive is technically not an apostolate.
Does that have any significance to you so that you stated the captive is not an apostolate?
Does it have, repeat the question, please.
Well, so I asked you, are you currently on the board of any of the apostolates? And then I asked you if you attended any of the board meetings of the apostolates, and then you felt it necessary to offer that the captive is not an apostolate.
I want to be clear that I am the chair of the captive, but it is not an apostolate.
All right, and so is it fair to say that since the inception of this bankruptcy on May 20th of 2020, other than the cemetery board, you have not been on the board of any of the apostolates or attended board meetings for any of the apostolates?
My recollection is I have not attended any board meetings of any of the apostolates.
Do you understand that within this bankruptcy, the apostolates have been separated from the chancery?
Yes,
All right. And do you know the reason for that?
they're not a debtor.
And they have different counsel, correct?
Correct.
And do you consult with their counsel as well?
I do.
All right. And how often do you do that?
2 or 3 times a week.
Did you consult with him about today's deposition?
No, sir.
You haven't said a word to Douglas Draper about today's deposition.
He said, good luck, that was it.
Okay. So you did say a word to him about the deposition.
No.
Objection. Mr. Draper's, the testimony is Mr. Draper said something to Mr. Eagan, not the other way around.
Okay. So tell me the circumstances, and I appreciate that, Pat. Tell me the circumstances whereby he would have known that you were being deposed to tell you good luck.
Jones Walker may have said something to him. I cannot speak for Mr. Draper. I was discussing something other than this deposition with him, and he said, good luck on the deposition. Simple as that.
What did you happen to be discussing with him at the time?
That is confidential between my counsel and me.
Do you consider Mr. Draper to be your counsel?
For the apostolates, yes.
Okay.
The finance counsel is broad, not just for the debtor.
Okay. So you only speak to him in your capacity as a member of the finance council?
And as delegated by the bishop.
Okay, but you just told me that because they, meaning the apostolates, are non-debtors, that there has to be a separation, correct?
That is correct.
And yet you consult with the attorney for the apostolates frequently, correct?
Correct.
And do you see any conflict in serving on the cemetery board while you represent the debtor in bankruptcy?
Objection calls for a legal conclusion by the witness.
You can answer it.
No.
Do you do any other volunteer work for any other organization?
Yes.
Tell me about that.
My oldest child's disabled. She is developmentally disabled at Magnolia on River Road. and I have championed the developmentally disabled for 47 years.
Go ahead, I'm sorry.
I think I've answered your question.
Okay, I didn't know if you were finished. And so, how much time do you volunteer for Magnolia?
In what time period?
Now?
Depends. Well, the session was just over.
Wait a minute. I'm just going to object to the relevance. We're here for your objection to the fee applications. I just don't understand the relevance of this line of questioning.
Well,
and
I'm-
I'm trying to be, I think we've spent a lot of time on irrelevant questions, but I'll give you some latitude, but I'd like you to focus on what we're here for.
Okay, well, I would appreciate it, Mr. Vance, if you would object to the form of the question or instruct the witness not to answer.
I object to the form of the question. Then.
Okay. I would appreciate no speaking objections because the federal rules don't allow that. And if you want to instruct him not to answer a question, that's your prerogative.
I wasn't instructing him not to
Okay.
answer the question, Mr. Trahan.
And
I'm just raising an objection to relevance.
So I'm going to just state this because we're not going to have any further colloquy. I have every right to determine the background of the witness, particularly having been presented as the representative for this issue. That's what I'm doing. I have every right to do it, whether you think it's relevant or not. You know, that's, again, your prerogative.
Well, if it gets into the level of harassment, we'll just terminate the deposition. But you proceed, Mr. Trahan.
I don't believe I've done anything to harass the witness. I'm asking him standard background questions, Mr. Vance. I think I have the right to do that. I don't intend to be argumentative with him. I certainly don't.
But you are.
I don't.
You are being argumentative.
I don't believe I am.
Yes, you are.
Okay. So, currently, how many hours do you volunteer a week for Magnolia?
Answer the question.
The session was just over, which creates, there's different time periods. I would say I still do 10 to 12 hours a week.
So, can you tell me how you first came to know Gregory Amond?
It was 40 years ago. I was in the Sarah Club, and I met him at the seminary.
Were you in the seminary with him?
No, sir.
So that would have been around the mid-70s?
Late 70s, maybe.
Okay. Do you, Mr. Eagan, have any sort of contract with the Archdiocese or any other entity involved in this bankruptcy?
No.
And who is representing you here today?
Pat Vance.
Are you being represented in your personal capacity or in your capacity as a representative for the Archdiocese?
As a representative of the Archdiocese.
Okay. And so in terms of your personal capacity, you have no attorney here today, correct?
That is correct.
Are there any documents that you're aware of, Mr. Eagan, that designate you as any type of representative in this bankruptcy?
No.
So can you tell me by what authority you represent the Archdiocese by which you are not employed?
By a delegation from the Finance Council and the Bishop.
Is that in writing?
No.
Were there meetings to determine that?
Yes.
And certainly there would be minutes for those meetings, correct?
Those minutes are privileged because council was there.
Okay, but there are minutes for those meetings.
Yes.
And do you know when that occurred, when that delegation occurred?
Can't remember.
Was it before the bankruptcy was filed?
contemporaneously.
All right, so it would have been somewhere around April or May of 2020.
Correct.
Do you consider yourself to be the Archdiocese of New Orleans corporate representative in this bankruptcy?
On the business side of the bankruptcy, I do.
Okay, can you explain to me what you mean by that?
The sustainability and feasibility of the debtor and all of the documents that are requested by both sides in the bankruptcy.
When you say documents requested by both sides, does that mean all of the documents?
No, sir. It means the documents relative to financial information.
All right. Do you know who any of the other corporate representatives are?
It would be the general counsel.
So in terms of the financial sustainability, the things that you are the corporate representative for, as a corporate representative, as you're doing here today, when you speak, it's as if the Archdiocese itself is speaking, correct?
I have been authorized by the bishop to respond to certain requests, yes.
Can you tell me who was on the Finance Council when this delegation was made?
It would be a guess. It was 4 years ago.
All right. Do you know any of the names? of
Yeah,
the people?
sure. Myself, Bill Finnegan, Rachel Muna, the Vicar of Finance, Father Patrick Carr, Father Lee Poche, Lloyd Tate, Calvin Tregg, Peggy Adams.
And so was there any necessary discussion when we filed this objection? You guys realized that there was going to be discovery conducted as to who was going to be the person to speak to this issue?
In discussion with Jones Walker, I offered, as the person who approves the bills and invoices, to speak to this issue.
And so aside from any of the Archdiocese lawyers, are you the person most knowledgeable at the Archdiocese about Jones Walker's fee applications?
I am.
Are you the person most knowledgeable about all fee applications?
I am.
So in terms of being the person most knowledgeable about the fee applications, is it your testimony that you know more about these fee applications than anybody else at the Archdiocese who deals with them?
Yes.
Do you have any other duties outside of the bankruptcy at the Archdiocese?
Ida and FEMA, the Ida repairs, and
Oh, Hurricane Ida.
I'm sorry.
That's okay.
And as the chair of the captive, I work with the Archdiocese on the insurance placement of property and casualty.
And so, average ballparking it for me, how many hours a week do you volunteer at the Archdiocese?
35.
And of that 30, approximately 35 hours, how much of that is related to the bankruptcy?
75%.
Have you logged the time that you volunteered relative to this bankruptcy?
No.
Have you ever tried to estimate that time?
No.
So the bankruptcy has been pending for about 216 weeks. And if we go down to 30 hours a week, that, by my estimation, is over 6,000 hours. You don't have to trust my math, but would you have any reason to dispute that you've put thousands of hours into this bankruptcy?
No.
And the Archdiocese has gotten the benefit of all of that work for free, correct?
That is correct.
In your role as a volunteer for the Archdiocese, do you treat this volunteer role the same as if you were either employed by the Archdiocese or if it was your own company?
I'm going to object to the form. Answer if you can.
Yes, probably.
I want to show you what we're going to mark as Exhibit 1. Sorry. I'll slide one down to you. Now tell me if you recognize that document.
Yes, but it's dated.
Right. Do you know if there is an updated organizational chart?
I haven't seen it.
And some of the people on this chart have been replaced, correct?
Or died. Correct.
All right. And you would agree that Gregory Eagan has ultimate control over all of the individuals and entities listed on this organizational chart?
Object to the form of the question. Answer if you can.
Yes.
And it's true, is it not, Mr. Eagan, that you are not now and have never been employed by the Archdiocese of New Orleans?
Yes.
Okay, and Dirk Wild is the CFO and Patrick Carr is the Vicar of Finance, correct?
Father Patrick Carr is the Vicar of Finance.
And they're both CPAs, correct?
Correct.
Okay. Are you a CPA?
No.
And my understanding is that both yourself and Patrick Carr have attended hearings in the bankruptcy court, correct?
Yes.
Okay. And so is he a corporate representative of the debtor as well?
Yes.
Prior to this bankruptcy, Mr. Eagan, what particular experience did you have with any bankruptcy?
As a businessman, a number of times clients went bankrupt, and so I understood the process, and that's it.
So how many bankruptcies would you say you had exposure to prior to this one?
30 maybe?
All right. Were you an advisor?
I answered that. They were clients that went bankrupt. So I dealt with the collection of funds that were owed to my company as a result of the clients going bankrupt.
You were a creditor, correct?
Correct.
Right. So my question is, did you have any type of consultation role in any of those bankruptcies?
No.
All right. And certainly you have never advised a debtor in bankruptcy prior to this, correct?
Correct.
Do you have any educational background in bankruptcy?
No.
Do you have any training as a financial advisor?
No,
Right. And you're not a licensed financial advisor, correct?
correct.
Are you aware that you have been described in this bankruptcy as a financial advisor?
Don't recall.
What I'm going to attach as Exhibit 2 is bankruptcy document number 2782. And if you would flip, I didn't include the whole order, although I'm happy to do that to save paper. This is a document entitled Memorandum, Opinion, and Order, and it deals with a motion to compel. Do you recall that?
No, sir.
All right. On the bottom of page 3 of that document, and onto the top of page 4, it describes you as a financial advisor. Do you see that?
Yes?
And that would be incorrect.
I have
Right?
a great deal of experience in reading financial statements throughout my entire career.
I understand that, sir, but you are not a financial advisor, are you?
I have a great, no, sir.
Okay. In any, I'll make, I got you, okay. Have you ever gone through bankruptcy in any of your personal businesses?
No.
And I think you answered this, but I'm not sure if I asked it correctly. Have you ever had any connection to any debtor in bankruptcy other than as a creditor or this bankruptcy?
No.
Do you have any training or experience at all in managing bankruptcy?
4 years of experience, yes.
Okay, well, let me ask a better question. In May of 2020, did you have any experience at all in managing a bankruptcy?
No.
Are you aware that there is an entire market for bankruptcy consultants?
Yes.
Have you ever explored retaining a bankruptcy consultant?
Yes.
And you did not do that, correct?
Incorrect, we did.
Okay, who's your bankruptcy consultant?
Chris Linscott.
And what is his role?
He is the formal financial advisor
So does he
to
manage?
the debtor.
I'm sorry.
To the
And-
debtor.
I'm sorry. I'm not meaning to cut you off. We're talking at the same time. And so does he manage the bankruptcy or do you manage the bankruptcy?
I manage the bankruptcy. On the business side,
You don't claim to be an expert in bankruptcy in any respect, do you?
correct.
And you do not have education, training, or experience to be a bankruptcy expert, correct?
Correct.
All right. And that would include the issue of attorney billing in a bankruptcy, correct?
No.
Okay. I know you do have.
I know how to read invoices.
All right. How did you learn how to do that?
I think it was 8th grade.
That you read attorney billing invoices?
No. I know how to read a invoice, and I've done it all my business career.
All right. Certainly in 8th grade, you were not reading anything remotely close to these fee applications.
That is correct.
All right. And you do not claim to be a bankruptcy expert, correct?
Asked and answered.
Okay. Answer it again, please.
I do not.
And so if someone claimed that you were an expert, that would be false, correct?
On May 20th, on May 1st, 2020, that is correct.
And so do you consider yourself now to be a bankruptcy expert?
I have learned an awful lot in 4 years.
Okay, that wasn't my question, sir. I think you testified earlier, and I'm following up on an answer you gave, that you are not a bankruptcy expert, right?
That is correct.
And so if anybody said that or put that in writing, that would not be true, would it?
I have a great deal of knowledge I've gained over 4 years. So yes, I'm able to communicate with lawyers and financial advisors at a level I could not do in May of 2020.
But what I'm asking you, sir, is you could not go into court based on education, training, and be qualified as a bankruptcy expert.
I'm going to object to the form of the question, and it also calls for a legal conclusion. But answer if you can.
Repeat the question.
Sure. You would agree that you could not go into any court and be tendered as an expert in the field of bankruptcy?
Object to the form of the question.
Yes.
Do you maintain an office on Walmsley?
I have a table that I use.
What else do you have other than a table?
That's it.
You have a chair, I would imagine.
Thank you for that clarification.
Well, I'm asking you.
I do not have a desk chair.
And where is your table located?
First floor of Walmsley Avenue.
Okay, and tell me what that would be near in the Chancery.
Office of Catholic Schools.
How close are you to the Archbishop's office?
He's on the second floor.
Aside from Mr. Vance and Mr. Mintz, what lawyers at Jones Walker do you speak to on a regular basis?
Samantha Oppenheimer, Lisa Futrell, Dirk Wegman, Caroline McCaffrey, Cove Gary, there's others I've talked to, but those are the ones I talk to regularly.
Did you make the decision with respect to our objection in this discovery not to produce Wayne Zarang, Susan Zarang, or Gregory Amond?
No.
Did you concur in that decision not to produce those individuals?
Yes.
Okay. In your estimation, why are they not being produced?
Because I'm the one who looks at the fees, and this objection is about the fees.
And so you would agree that if we wanted to ask Mr. Zarang, for example, questions about his billing, he would know better than you would about that?
His billings, in my estimation, from an accounting perspective, are immaterial.
What do you mean?
Materiality, as an accountant, speaks to the percentage of an item relative to the total.
Are you an accountant?
I was trained as an accountant. That is correct.
But not a CPA?
That is correct. I did not sit.
And so when we get to particular billing entries, for example, when Wayne Zarang writes communication with client representative, how are we supposed to know who that client representative is?
I don't know the answer.
All right, and that's my point, sir. If I wanted to know the answer to that, I would have to ask Mr. Zarang, correct?
Correct.
Do you know who pays the apostolate's fees and costs?
Yes,
Who?
the apostolates.
Okay. How is that done? Is it a pooling agreement?
I'm going to object to the relevance of this line of questions.
Okay. Are you going to instruct them not to answer?
Yes.
As the
Excuse me, Mark, get me some water, please. Go ahead.
like I said, if at any time you
No, I
want to
just wanted some water.
take a break, let me know. As the corporate representative, do you consider yourself to be bound by the protective order?
Yes,
Okay. And you've been involved in the mediation sessions for this bankruptcy, correct?
yes,
Do you consider yourself to be bound by the mediation privilege?
yes.
I want to take a look what I'm going to mark as Exhibit 3. This is
Thank you.
an excerpt from the general order regarding procedures for complex Chapter 11 cases, which is dated December 4th of 2019. Have you seen this document before?
Don't recall.
Okay. So you don't recall ever having reviewed this document?
That is correct.
I want to ask you to flip to the second page of that.
We're looking at page 16.
Yeah, it's 16 of 18, and under section Roman numeral 15, mediation. Do you see that?
I do, yes.
Okay. And if you flip to the next page, it's the third page of the exhibit, it's page 17 of 18 of that particular general order. Section F states, and I quote, "The mediator and the participants in mediation are prohibited from divulging outside of the mediation any oral or written information disclosed by the parties in the course of the mediation," close quote. Did I read that correctly?
You did.
And you understand and have abided by that, correct?
I have.
All right. Can you tell me, Mr. Eagan, if the Archdiocese of New Orleans is paying 100% of its legal fees in this bankruptcy?
That depends on the timing.
Okay. Tell me what you mean by that.
The fee statement's 80% of the fees and 100% of the expenses are paid. And then in the fee application, 100% is paid. The only thing we have not paid is, and we don't know the amount, is counsel for the bonds, the 2017 bonds. So that has not been paid.
Okay. I probably should have asked a clearer question. In terms of the attorney's fees that are being paid, is it only the Archdiocese that is paying those fees?
Yes.
My understanding is that counsel answers to the corporate representative. Did the Jones Walker lawyers answer to you, Mr. Eagan?
It answers to a team of Susie and I and the Archbishop.
Do you know, sir, why Susan Zarang is not present today?
No,
Okay. You have no idea why she's not here.
I'm the one giving the deposition.
But that wasn't my question, sir. She's
So that I answered it. I don't know why she's not here.
Do you know if Wayne Zarang makes a generator fee off of this bankruptcy?
I do not know.
All right. If he does, as you sit here, that was never disclosed to you, correct?
Jones Walker does not reveal their compensation policies to me.
Really?
That is correct.
Okay. So, aside from whether they've revealed it to you or not, has the Archbishop or anybody else ever told you that Wayne Zarang is making a generator fee off of this bankruptcy?
The Archbishop wouldn't know that.
Okay.
So no,
Okay.
the Archbishop has not told me that.
All right. And so your testimony is the same with respect to what you said, that they wouldn't know what the compensation scheme is for Jones Walker, correct?
That is correct.
Well, certainly Ms. Zarang should know because she's married to Mr. Zarang, correct?
They are married, yeah.
Okay. And so she should have a pretty good idea of what her husband's compensation scheme is, correct?
Object to the form, calls for speculation.
I don't know the compensation plan, and I don't know Susie and Wayne's tax relationship at all.
I didn't ask you about their tax relationship, sir. I asked you if the wife knows her husband's compensation scheme.
I can't answer that question.
All right. You do know, sir, that Jones Walker was not brought in to defend these child rape cases until Ms. Zarang took over from Wendy Vitter as legal counsel.
It's prior to my time.
Okay. You don't know anything about that?
I don't know this. I don't know how the switch happened. I don't know. From Dennis Show to Jones Walker.
Okay, so as the corporate representative, you don't know how Jones Walker
I was not-
Please let me finish. You don't know how Jones Walker showed up to defend child sexual abuse cases when they never had before.
I do not know the answer to that question. That is my testimony.
Have you ever spoken to anybody at the Archdiocese about that?
No.
Does Gregory Eagan ever review any of the legal bills?
I review with him through the Finance Council and individually a high-level view of the cost of the bankruptcy.
What does that mean?
Means I tell him and the Finance Council on a regular basis how much money we spent and by whom.
All right. And does he ever express to you, hey, Lee, I want to look at those bills?
No.
In the 4 years and 2 months that this bankruptcy has been pending, it's your testimony that Gregory Eagan has never expressed an interest to you to look at any particular billing entry.
That is correct.
Would you say that you have plenty of private conversations with the Archbishop?
I do.
And do you talk to him about the cost of the bankruptcy?
I do.
And what is his response when you tell him how much this is costing?
He says we need to settle this bankruptcy as quickly as possible.
Does he think that the costs relative to this bankruptcy are excessive?
Yes.
Do you recall any other conversations you've had with him with respect to legal bills in this bankruptcy? I would imagine you talk about it a lot, right?
Regularly.
Okay. Can you tell me any other conversations that you remember?
Not specifically.
What conversations did you have with him about appearing here to be deposed today?
Very little.
What?
I'm being deposed by Soren. I didn't know you would depose me. I thought Soren was doing it. And I said, I'm being deposed by Soren on the fee objections. That's all I said.
And what was his response?
Sorry you have to do that.
That was it?
That's it.
He expressed no curiosity as to what the content of the deposition might be?
No.
Can you tell me who is on the special committee of the Finance Council that reviews these bills?
Myself, Hal Crosby, and Rachel Muna.
What is Mr. Crosby?
He's a chaff.
He's
He's a lawyer chaff. Rachel Muna is a CPA lawyer at Entergy.
And what does Mr. Crosby do at Schaff McCall? His area of practice.
I think it's real estate transactions, but I'm not sure.
And so, as it relates to the review and approval of these fee applications, it's just you three.
I review and approve the fee statements, and I report and I review and approve the fee applications, and I report back to Hal and Rachel and the Finance Council.
And who's on the Finance Council currently?
The same names I gave you, and take off Peggy Adams, add Hal Crosby, and David Gallo.
David Gallo is or is not on?
Is.
Okay. So David Gallo is involved in decision-making about the payment of attorney's fees in this bankruptcy?
He just came up.
I'm sorry. I know you want to answer my question. I have a slow delivery and I apologize. Go ahead.
Ask your question again.
Sure. David Gallo is on the Finance Council, involved in making decisions with respect to the payment of attorney's fees in this bankruptcy.
I would object to the form of the question. Answer if you can.
He's only had one meeting with the Finance Council and has not yet been engaged in that particular topic. He was just appointed.
When you testified earlier, you distinguished approving statements from approving the fee applications, correct?
Different process, yes.
Okay. Tell me, I want to know that process from the time you guys get the billing statements until the time it becomes a fee application.
Please ask your question again, because I'm not sure I understood it.
Okay. I want to know the process that occurs, and we're on the 11th interim fee application now, the process from the beginning of the submission of these fee statements until they're filed into the record as an interim fee application.
There is a share file at Jones Walker through which I download every statement. So that's the statement process. The fee application process is similar, except I have to analyze the holdback of the 20% of the fee statements to include payment of the fee application.
And so at the inception of this process, when you get this information through a share file, when you go to the special committee of the Archdiocese Finance Council, do you present them with the original fee statements?
I do not.
Okay. What did they see?
They see a summary of what happened.
Explain that for me, please.
I keep a spreadsheet on every different professional by month, by expense, by the 80% in gross, and the holdback. That's what I share with the Finance Council.
And so do you create this spreadsheet, or does Jones Walker?
Oh, I do.
Okay. And so you share that Excel spreadsheet with the other two members of the...
I sit at the Finance Council meetings and I share the information contained in those documents relative to the cost of the bankruptcy.
All right. Do the other two members of the special committee see anything before the final fee application?
No.
Does anybody, setting aside the lawyers, does anybody other than you engage in that process of putting these statements into an Excel spreadsheet?
I do that.
And so the period of time between when you get the statements and when they go to the Finance Council or the Special Committee of the Finance Council for approval, you are the only individual dealing with this, correct?
No.
Okay, who else?
I present the paper document of the fee statement and the fee application, two different processes, to Christopher Countess, who is our manager of the accounting department.
Spell his last name, please.
Countiss, I think it's two S's.
Okay, so in this process, before we get to a fee application, what is Mr. Countess's role?
To place or delegate to have been placed the document in the payable systems to be paid.
All right. And that's before the fee application has been submitted?
I don't understand the question. Try to answer it differently, please.
I'll ask it differently. So you've told me that there is a different process for the fee statements and the applications, correct?
Correct.
And that nobody on the Finance Council or the Special Committee of the Finance Council has anything to do with the first stage, which is the statements, correct?
Correct.
All right. And so in that process, it's just you and Mr. Countess, correct?
That is correct.
All right. And I think you said he puts them in the system and submits them for payment?
Correct.
But shouldn't that only be done after they're approved by the committee?
No, I approve it. I've been delegated to approve it, and they review my approvals.
Okay. So when does the payment occur with respect to the application being filed into court?
Shortly thereafter.
All right. But he arranges for that beforehand, correct?
That is correct.
All right. And so in that process where you provide this information, Mr. Countess, you make your Excel spreadsheet, you give him the information, you would agree with me that those bills have already been approved for payment before they're ever filed into the system.
Correct.
And so have you ever had occasion in any one of these 11 interim fee applications where either you or someone on the committee, subsequent to the phase of approving the statements, takes something out?
Take something out.
Sure. Reduces the bill, takes out a bill, changes it, modifies it?
I review every line item of every professional statement that is sent to us, regardless of who it is, whether it's the counsel for the debtor, or whether it's Jones Walker, or whether it's our financial analyst. When I do that, I typically, on that day of the month when I do that, I usually have concerns about certain line items. I either call or email Mark Mintz and express our concerns, my concerns.
At that point, have there been any amendments between the statement phase and the application phase?
Amendments.
Sure. Like if we take the 11th interim fee application, and when those are submitted to you as statements and you put them into an Excel spreadsheet, and then you call Mr. Mintz and say, hey, what about this entry? What about that entry? have there ever been any changes between the statement phase and the application phase?
Typically, we hold those to the end of the bankruptcy, where we'll have discussion with the professionals about areas that we might object to.
Do you know how many times you've done that?
To object to Mr. Mintz on line items?
Yes, sir.
Every month.
So there would obviously be a difference between every month, the difference between the fee statements that you approve and the ultimate application that's filed into the record.
No. What there would be is the creation of a concern on my part relative to line items on a statement and or application that we will defer our objections till the conclusion of the bankruptcy, which is typical as as it's been described to me in the bankruptcy proceedings.
How do you maintain those potential objections?
I have a list of items that I'm concerned about.
And do you keep that in one document?
No,
How many documents do you keep those in?
I couldn't answer that question.
But you could produce those documents, correct?
Probably. I'd have to find them.
So let's take the...
But I generally know the topics that I object to.
Let's take the 11th interim fee application, for example. You said that you have entries that you object to every month, correct?
For all the professionals, yes.
All right. I'm just talking right now about Jones Walker. And I think you testified, and I think it's going to be clear on the record, that you have objections that you convey to Mr. Mintz every month, correct?
That is correct.
Okay, and so for this 11th application, you will have 4 different series of objections to Jones Walker fee entries. correct?
Not necessarily. When you asked your question, my assumption was the entire body of fee statements and applications, including all financial analysts and legal teams. So I object. I'm blind as to who I object to. It could be Jones Walker. It could be the Stang Group. It could be Lloyd. I'm blind about who it is because it's my responsibility to concern myself with making sure that this process is the appropriate process.
But all of the fees have an entry for the name or initials of who entered them, correct?
No.
Okay. And so what you're telling me is whether it's Jones Walker or Lloyd or Pachulski Stang, that you don't even know when you're reviewing the...
That's not...
Let me finish.
Finish.
Okay.
That you don't even know when you're reviewing these bills who submitted them?
The firms that you mentioned appropriately followed that process with names or initials, but there are some ancillary professionals that do not include the names or initials.
Okay, but I'm not talking about ancillary professionals, sir. I'm talking primarily about Jones Walker, and you can talk about the other lawyers for the committees if you feel the need to. But I'm trying to understand this process because you initially told me that you don't know who they're coming from, correct?
Initially told you, please restate that because I know Jones Walker and who's making the entries.
Okay.
If you interpreted that I didn't, then I misstated. I know exactly who makes the entries at Jones Walker.
All right. And you know that because their initials are on whatever particular fee entry they put in, right?
Yes.
All right. And are you telling me that's different for Pachulski and Lloyd?
No, they're the same.
Now, before these fee applications are filed into the record, who reviews them?
Well, Jones Walker reviews them before they're submitted to me. Are you talking just Jones Walker? I'd rather, if you don't mind, sir, when you ask the question, please indicate whether it's Jones Walker or anyone else, because I want to make sure I answer your question appropriately.
Fair enough. So, aside from the lawyers, and it's you and the two other members of the special committee of the Finance Council, and then you have the other members of the Finance Council, and so all of those individuals review the fee application before it's filed, correct?
No.
Okay. Tell me where I went wrong there.
I report back to the Finance Council and Special Committee the results of both the statements and the fee applications.
Okay. And so in terms of reviewing individual entries, you would agree with me that relative to the statements, you're the only one who reviews those before they go to Mr. Contis, correct? Outside of the lawyers.
Yeah, I just wanted, yes.
All right. And then with respect to the fee, the application before it's filed, you are still the only one who reviews every individual entry, correct? Outside of the lawyers.
The statements make up 75% of the fee application, with one exception, the current month. So the statements have been reviewed prior, and it's the holdback that is paid. Then the month in question is approved at 100%, and I review every entry of that statement within the fee application.
Right. And only you do that,
Correct.
And then before you, when you present your analysis to the special committee, they have not previously been given either the billing statements or the fee application, correct?
Correct.
All right. And so, same question as it relates to both the fee statements and the fee applications in terms of anybody at the Archdiocese or on behalf of the Archdiocese reviewing these things, it's only you, correct?
That is correct.
All right. And so you would also agree, Mr. Eagan, that from your testimony, there is no individual employed by the Archdiocese who reviews these billing statements or the fee application before the fee application goes into the record, correct?
W-2 employees?
Yes.
No.
Is there any other type of employee, like a 1099 employee?
Well, in nonprofits, you have people that serve at the will of the board of the nonprofit, which I do at Magnolia, and which I do at the Archdiocese. So that's my answer.
All right. You know of no employee who participates in that process?
That is correct.
Are we getting to a convenient breaking point?
Whenever y'all want.
Yeah, I'd like to
Yeah.
take a break.
Sure.
What time is it?
Now off the record, the time is 10:08. We're now back on the record, the time is 10:18.
You mentioned earlier, Mr. Eagan, an attorney being present at the Finance Council meeting where the delegation was made to make you the representative in this bankruptcy. You recall that?
Yes.
Who was that?
Mark
attorney?
Mintz.
Okay. I know you want to answer my questions, and we have this. It's going to make her job easier if I finish. So does Mr. Mintz attend every meeting of the Finance Council?
No.
Is there an attorney present for just regular Finance Council meetings?
Some of the Finance Council members are attorneys.
Any attorney for the Archdiocese?
No.
All right. Does Ms. Zarang attend those meetings?
No.
Are there any attorneys, not one of the members of the special committee, do any attorneys ever attend those meetings of the Special Finance Council where you discuss with the other two members of the special committee the issue of attorney's fees?
No.
Let's talk about the Finance Council, because they do play a role in this, correct?
Yes.
Okay. And so how does one get selected to be on the Archdiocese Finance Committee?
It's an appointment by the bishop.
Okay. Do you know what the criteria are?
No.
And how long have you either served on that Finance Council or been affiliated with it?
8 to 10 years, I guess.
Okay. Let's take David Gallo, for example. Do you know how he was selected to be on the Finance Council?
Yes.
How?
We needed a person who was an expert in construction to help us, and he fit that need.
And same question with respect to the special committee. How were those two individuals selected?
I don't recall.
Okay. Do you know if any of these individuals have any training or experience in auditing bankruptcy attorneys' fees?
No.
Do you have any education, training, or experience in auditing legal fees?
No.
Are you aware that there is an entire market out there for people who audit legal fees all day long?
No.
Okay. So that's news to you?
I'm not sure I fully understand the depth of your question.
Sure, that there are individuals with the education, training, and experience to audit attorney's fees. Were you aware of that?
I'm sure there is.
All right. But you didn't know that, correct?
I've never discussed that. There were people that did that.
Now, as far as reviewing attorney's fees in this bankruptcy, what was your training to be able to do that?
I've reviewed invoices through my entire career. Other than that, none.
You would agree with me that reviewing attorney fee applications or billing statements in a bankruptcy are a whole lot different than reviewing invoices?
No.
Okay. In your estimation, they're the same?
Similar.
Do communications about Jones Walker's bills between members of the special committee, between those two individuals, exist?
Which two individuals?
The two individuals on the finance committee, which are Mr. Crosby and Ms. Muna?
Re-ask your question, please.
Sure. Do they communicate about the attorney fee issue
With me?
with each other?
Yes.
All right. Do they communicate with you?
Yes.
Okay. Do communications about Jones Walker's bills between members of the special committee and Gregory Amond exist?
No.
Do,
Except at the Finance Council.
all right. So what would that be?
Special committee.
All right. Would there be minutes?
No.
Are there emails?
Can't answer that. Don't know.
All right. Are there emails between you and Gregory Amon about Jones Walker's fees?
No,
Why not?
it's verbal,
Always?
always.
Why?
It's the way I prefer it. It's the way he prefers it.
Why?
Don't know.
You don't know why you prefer it that way?
It's more efficient.
You would agree with me that it's better documented if you put it in an email or a text message, correct?
Object to the
necessarily.
form, answer if you can.
Not necessarily.
Do communications about Jones Walker's legal bills exist between either members of the Finance Council or the Special Committee and Susan Zarang?
No.
Why not?
Asked and answered, she's not involved in the approval of the legal fees.
Okay, well, I'm not asking about approval. I'm just asking if they communicate with her at all about this.
No.
Do you know if there are any notes kept relative to any special committee or Archdiocese Finance Council meetings relative to the issue of attorney's fees?
No.
And certainly there are emails among the members and you, correct?
Mostly verbal.
Did you consult any written guidelines at any point in determining the propriety of attorney's fees?
No.
So as the individual responsible for approving these fees, you have never looked at any of the U.S. Bankruptcy Court guidelines or the guidelines from the United States trustee?
No.
Did you know those existed?
No.
And you're learning that from me right now, correct?
Yes.
And so likewise, the members of the special committee, in their role in approving attorney's fees, do not review any guidelines, correct?
I do not know that.
Okay. Have they ever told you they did?
No.
Okay. And to your knowledge, no one has ever provided them with any guidelines to determine the propriety of the fees, correct?
No.
I asked you earlier about how you were selected to be the corporate representative. Are you aware of any written document whatsoever establishing you as the corporate representative?
No.
You're aware, Mr. Eagan, that there have been, many media stories addressing the exorbitant cost of this bankruptcy, correct?
Yes.
But it's your testimony that the CEO of the debtor and its general counsel have nothing to do with approving these fees, correct?
Correct.
Is the majority of your time as it relates to this bankruptcy, Mr. Eagan, devoted to the issue of reviewing and approving attorney's fees?
No.
How much time would you estimate you spend on that per week?
2 days a month.
How much time did you spend reviewing the 11th interim application?
Don't recall.
Do you find review of these bills to be tedious and time-consuming?
Yes.
And so just to be clear, as it relates to particular billing entries that you take issue with, that would be your role and yours alone, correct?
Yes.
Did you review the motion for summary judgment that Jones Walker filed relative to the fee objection?
Yes.
Did you approve the work to be done on that?
Yes.
Did you read it?
Yes.
Did the members of the Finance Council or the special committee read it?
No.
Does the special committee also review all the professional fees? And that could be committee counsel, retained experts.
They do not review those bills. They review the total amounts paid.
And you would agree with me that by that time you've already made the decision as to what's going to be paid and what's not, correct?
Yes.
Does the special committee review the fees of the ordinary course professionals?
No.
Do you know, without telling me anything that you consider to be attorney-client privilege, how much the apostolate's fees have been in this bankruptcy?
I don't recall.
Do you have a general estimate?
No.
Okay. As the corporate representative for the Archdiocese of New Orleans relative to financial issues, do you consider yourself to be a cost-conscious individual?
Absolutely.
And you would like to see the Archdiocese pay less in fees, correct?
Yes.
All across the board, correct?
Yes.
Do people outside of this bankruptcy, outside of the people at the Archdiocese and the lawyers, express to you that they believe the costs of this bankruptcy are outrageous?
Object to the form of the question. Answer if you can.
Please rephrase.
Sure. Like people, friends, relatives, people on the street who know that you're involved in this, do they express their opinions to you that these fees and costs are outrageous?
Object to the form of the question. Answer if you can.
Yes.
Do you agree?
Yes.
Now, I want you to take a look at what I'm going to mark as Exhibit 4. And what I presented to the witness is 11 U.S.C. Section 330 entitled Compensation of Officers. Have you ever reviewed this before, Mr. Eagan?
No.
And so you're seeing that for the first time today, correct?
Yes.
So I want to ask you a couple of questions about this, and let me first establish that you were unaware of this particular part of the United States Code that deals with compensation in a bankruptcy, correct?
That is correct.
Okay. Would you like to have had this material before you started reviewing legal bills?
Not necessarily.
Do you think less information is better than more, sir?
No.
And so if you look in Section A1A, it calls for reasonable compensation for actual necessary services rendered, and then you'll see attorney and by any paraprofessional person employed by any such person. Do you see that?
I do.
All right. And you see in B3, it says the court shall consider the nature, extent, and value of such services taking into account all relevant factors, including time spent, rates charged, whether the services were necessary to the administration of or beneficial at the time at which a service was rendered toward the completion of a case under this title. Did you see that part?
I do.
And if you turn to the next page, whether the services were performed within a reasonable amount of time commensurate with the complexity, importance, and nature of the problem, issue, or task addressed. Did I read that correctly?
You did?
Okay, and that's important, right?
Yes.
All right. And if you look at section E, with respect to a professional person, whether the person is a board certified or otherwise has demonstrated skill and experience in the bankruptcy field. And that's for the bankruptcy professionals, correct?
Correct.
And then section F, whether the compensation is reasonable based on the customary compensation charged by comparably skilled practitioners in cases other than cases under this title. Do you know what that means?
I do not.
All right. Do you have an appreciation reading that, what it means?
Objection calls for a legal conclusion. Answer if you can.
No. Looks like common sense to me.
All right. And if you go down to section 4, it says, except as provided in subparagraph B, the court shall not allow compensation for, under number 1, it says unnecessary duplication of services. You would agree with that, correct?
Yes, sir.
And so if you have the same lawyers reading a one-page order, you would agree with me that that's duplication of services.
would
Objection
not-
to the form of the question.
I would
Answer
not
if you
agree
can.
with that.
Okay. And the services have to be reasonably likely to benefit the debtor's estate or necessary to the administration of the case, correct?
Yes.
I'm going to attach as Exhibit 5 a document from the Federal Register, Volume 78, number 116. And if you look in the middle column, Mr. Eagan, it's entitled Department of Justice, Appendix B, Guidelines for Reviewing Applications for Compensation and Reimbursement of Expenses, filed under United States Code by attorneys in larger Chapter 11 cases. Did you see that?
I do.
Have you ever seen this document before?
I have not.
And so as the individual responsible for the billing issues for this debtor, not only have you not reviewed these guidelines, you did not know until today that they existed, correct?
Yes.
And so in preparation for your deposition, Mr. Eagan, and I don't want to know what was said, but none of the lawyers from Jones Walker showed these documents to you?
Objection to the form of the question.
You can answer it.
Calls for attorney-client privilege.
I would agree.
No.
Attorney-client privilege.
Yes.
Yes.
I instruct you not to
Yeah.
answer.
Okay. And so certainly the last exhibit and this document, which we're going to talk about, if you had not seen either of these documents, it's safe to assume that the other members of the Finance Council had not either, correct?
Objection to the form of the question calls for speculation.
Cannot answer that.
Have they ever told you that they've reviewed these?
No.
All right. Do you know if the non-bankruptcy lawyers at Jones Walker have familiarized themselves with these guidelines?
I do not know.
Have you seen a single billing entry in the 4 years of this bankruptcy where a Jones Walker non-bankruptcy professional has billed for reviewing any of these guidelines?
Rephrase, please.
Sure. In the 4 years that you've been reviewing billing statements or fee applications, have you seen a single entry where any Jones Walker non-bankruptcy lawyer has billed for reviewing this document, the guidelines?
I do not recall that that happened.
All right. You would agree that by looking at what I just handed to you, it would take some time to read this entire set of guidelines.
I would agree.
And so at least as it relates to your role in this, you have not utilized any guidelines when you're reviewing fee statements or fee applications, correct?
That is correct.
Now, I want you, if you would, to turn to the second page of this document, which in the top right-hand corner is numbered 36249. And I want to go to that middle column. Do you see where the bold writing is?
I do.
Okay. And so there's a section 1 that talks about goals, correct?
I see that.
All right. And I'm going to ask you to read to yourself paragraph A.
I've read it.
Do you know, Mr. Eagan, if Jones Walker's bills in this case are subject to the same level of scrutiny and accountability as Jones Walker's bills are in non-bankruptcy engagements?
I cannot answer that.
You don't know, correct?
I do not know.
I'm going to ask you to read section B to yourself, please.
Section, the entire section?
Section B.
Section, I'm sorry, oh,
Right.
1B, I'm sorry, okay. Read it.
Okay. Would you agree, Mr. Eagan, that the bankruptcy lawyers at Jones Walker generally bill at a higher rate than the non-bankruptcy lawyers?
I would not agree with that.
All right. Tell me on what basis you would disagree with that.
Because we negotiated a lower fee at the beginning.
Okay, but that's, and I want to talk to you about that, but that's not what I'm asking you. I'm asking you in terms of hourly billing. Let me give you an example. Jeff Tillery's been practicing for close to 40 years, right?
I don't know.
Okay, I'm telling you, he has been, about 37 years. His hourly billing rate is $300 an hour. Mr. Mintz's hourly billing rate is $190 per hour higher than that. And Mr. Mintz, as I understand it, has been a lawyer for about half as long as Mr. Tillery. Are you aware of that?
I didn't know when Jeff or Mark graduated from law
Okay.
school.
All right. So let's take that proposition and let me ask you the question again. Would you agree that the bankruptcy lawyers at Jones Walker generally bill at a higher rate than the non-bankruptcy lawyers?
I would disagree with that.
Okay. Can you tell me one non-bankruptcy lawyer who has billed into this case who has a comparable billing rate to either Mr. Vance or Mr. Mintz?
I cannot.
Okay. And I want to ask you to read section C to yourself for me, please.
Done.
All right. Would you agree with me, Mr. Eagan, that vague billing entries do not increase disclosure and transparency?
Yes.
All right. And again, we talked earlier about when somebody says email to client, conversation with client, and I can tell you I don't know who that is when I read those. You would agree with me that if you don't know who it is, that's a vague entry.
Yes.
Okay. And I'm going to ask you to read section D to yourself, please.
Done.
As we're going through these, do you believe that these guidelines are intended to increase Jones Walker's accountability to the Archdiocese for its billing practices?
Objection calls for a legal conclusion. Answer if you can.
I just don't know how to answer that question. I can't answer that question.
Okay. As you're reading through these and we're going through it, and I think on the last exhibit, you said that's just common sense, correct?
I did.
All right. And so my question is, do you believe that these guidelines increase Jones Walker's accountability to the Archdiocese for its billing practices?
Same objection. Answer if you can.
I'm not sure.
I want to ask you to take a look, read to yourself paragraph E, please.
Done.
Right. And so in terms of client involvement in the compensation process, based on your testimony thus far, that's only you, correct?
Compensation?
Yes.
Please rephrase.
Sure.
I look at that as a W-2. So
You look at what as a W-2?
compensation typically applies to an employee. So rephrase your question so I better understand it.
Sure. The document we're reviewing now deals with attorney compensation in a bankruptcy. So that's the predicate, the compensation is the compensation to Jones Walker. Clear?
Yes.
And so in terms of client involvement in that process, you would agree with me that you are the only individual on behalf of the Archdiocese who has any direct involvement with Jones Walker in that process.
I would agree.
And then read section F to yourself, please.
Done.
Is it your position that the review of these fee applications and the payment of these fees is as efficient as it could be?
I would agree.
And we only have 2 more of these. I'm not going to have you read this whole thing. Look, if you would, at paragraph F.
We just did F.
Yeah.
Oh, we did F, I'm sorry. G.
Done.
Okay, so you understand that whether it's Jones Walker, Pachulski Stang, Locklord, that once there is an objection, that the burden is on that particular professional to prove their fees.
Yes.
All right, did you know that before today?
I generally understood that.
All right, and then the last one I want you to take a look at is H.
Done.
Would you agree with me, Mr. Eagan, that with respect to this bankruptcy, there is very little public confidence in the integrity and soundness of the bankruptcy compensation process?
I would not agree
Okay, tell me why.
because I could not answer that question.
All right, you just don't know.
I just don't know.
All right. And so when the media talks about the fees being outrageous, when people you bump into talk about the fees being outrageous, wouldn't that indicate to you that there is not public confidence in the soundness of this process?
I object to the form of the question. Answer if you can.
There's a lack of understanding by many about these bankruptcy proceedings, which in itself does not necessarily mean that someone has been overpaid.
Okay, but that really wasn't my question.
Then re-ask it.
My question is, would you agree with me that with respect to this bankruptcy, there's very little public confidence in the integrity and soundness of the bankruptcy compensation process?
Object to the form of the question.
I would not agree.
All right. Has anybody outside of this bankruptcy, outside of the Archdiocese, outside of Jones Walker, come up to you and said, I think the compensation process is working great?
No.
Has any media story that you've seen opined that the costs relative to this bankruptcy are completely acceptable?
No.
Okay. Do you know what the comparable services standard is?
No.
All right. I want you to take a look at the very bottom of that same column we've been looking at, Mr. Eagan. And that is subparagraph B of subsection 6.
Done.
All right. Do you know if any of the non-bankruptcy lawyers who have billed into this bankruptcy have billed into this bankruptcy at a far higher hourly rate than what their hourly rate is outside of this bankruptcy?
I do not know that.
That would be very concerning to you if what I just said was true, wouldn't it?
I do not know what they bill outside of this bankruptcy.
But you should know that, correct?
No.
Okay. So what you're telling me, sir, as the corporate representative relative to the billing issue, that if Jones Walker is elevating the hourly rate of certain attorneys within this bankruptcy, that would be of no concern to you.
We negotiated a discount relative to their normal standard hourly rate of the professionals dealing in this bankruptcy.
Well,
So the rate was down, not up.
what if the rate went up? What if the rate doubled?
That's speculation.
Is it?
Yes.
Do you know who Robert Walsh is?
No.
Mr. Walsh has billed into this bankruptcy on behalf of Jones Walker, and it's your testimony, sir, that you don't know who he is.
I don't recall him, no.
So you don't know what he's done in this bankruptcy.
I do not know.
And he is billed in this bankruptcy at an hourly rate of $400 an hour. And certainly you would expect that to be his hourly rate for everything he bills, correct?
Not necessarily,
Why?
because we negotiated a discount on the lawyers within Jones Walker to deal in the bankruptcy.
Okay, you're losing me here.
Well, I'm sorry.
If an attorney's hourly rate is significantly increased, but only when he or she bills into this bankruptcy, you would agree with me, that's not a very good negotiated deal, correct?
I do not believe that exists, but I answered your question that if it did exist, I would be concerned.
All right. Because if it did exist and lawyers are billing into the bankruptcy at a much higher rate than they bill for their other work, non-bankruptcy lawyers, they would be ripping you off, right?
Again, I don't know how to answer that question, so I don't know.
Truthfully, I would ask you to answer it.
Well,
I'm going to object. I think we've now gotten into the level of argument, Mr. Trahan. You're being argumentative. You have no idea what the standard rates of the lawyers in this case are.
We're going to find out.
You don't know when you're asking these questions, though.
You don't
So
know.
you are being
You don't know
argumentative.
what I know and what I don't know. Anyway, I apologize. That was an aside.
That's okay.
Are we done with this document?
No,
Okay.
no, but I'm going to attach as Exhibit 6 Do you recognize that particular document?
Yes, sir.
And for the record, what do you recognize that to be?
It's the summary of the total hours and fees by pay for professionals for a certain period of time. I assume 11.
All right. Now, it is 11. And if you look at that document, you would agree with me that Allison Kingsmill, who's been practicing for 9 years, bills $100 more per hour than Wayne Zarang and Jeff Tillery, who have each been practicing for over 35 years, correct?
I would agree.
Why is that?
Jeff Tillery, Allison Kingsmill, is involved in an area of the bankruptcy that deals with cases. I do not see proofs of claims. So I cannot speak to Allison's compensation.
And that's what I'm asking you. If a lawyer who's been practicing for less than a decade, who is not a bankruptcy professional, is making $100 more per hour than litigation partners who have been practicing for nearly 40 years, you have no explanation for that, do you, sir?
I do not.
And if you look at the compensation for Carolyn McCaffrey, do you see that?
I do.
Ms. McCaffrey is an associate who has been practicing for only 4 years, and she has the same billing rate as Mr. Zarang and Mr. Tillery, correct?
Correct.
Do you think that comports with the section that you just read relative to the comparable services standard?
Objection to the form of the question calls for a legal conclusion.
I-
Answer if you can.
I cannot answer that question.
You just don't know, correct?
I just don't know.
You don't know why certain lawyers are being paid more than others, correct?
That is correct.
Do you know if Allison Kingsmill and Dirk Wegman bill $400 an hour for their work outside of the bankruptcy?
I do not know.
Did you ever ask?
No.
And as we looked at earlier, if you go down to the next section, which is section C, staffing inefficiencies, do you see that?
Yes.
Again, do you understand that duplication of effort is sought to be minimized or eliminated by these guidelines?
I understand that.
And that includes, and I quote, if you look down to about the middle of that paragraph, do you see the sentence that begins with the United States trustee may object if any duplication is unjustified?
I see that.
And it says, and I quote, if multiple professionals unnecessarily attend hearings or meetings, close quote. It says that, right?
Yes.
Do you know, sir, if there's been a single hearing, whether in bankruptcy court, district court, or the Fifth Circuit, where only one Jones Walker lawyer has attended?
I cannot answer that question.
Well, you would know by reviewing their fee applications who attended what hearings, correct?
That is correct.
Would you be able to dispute it if I told you that there has not been, to my knowledge, a single hearing, whether it's my appeal, Mr. Adams' appeal in the Fifth Circuit, whether it's litigation in the district courts or in the bankruptcy court before Judge Grable where multiple Jones Walker lawyers have been at every single hearing?
Yes, I believe that there is a necessity for multiple lawyers in certain circumstances.
In certain circumstances, correct?
Correct.
What are those circumstances?
Could be a hearing.
And do you know why multiple lawyers would attend any particular hearing?
Many lawyers have areas of expertise that complement the others.
I want you to take a look at, go forward to page 36, 254 in the top column. Do you see subsection F,
I'm sorry, where are we? I got lost.
36, 254? It's on the left-hand side, Pat.
Thanks, I got it.
Can you read subsection F out loud, please?
If more than one professional attends a hearing or conference, the applicant should explain the need for multiple attendees.
Have you ever seen a single entry in any of Jones Walker fee applications where an explanation was given for more than one lawyer being present at a hearing?
Yes,
Which one?
I can't recall exactly.
Not a single one, right?
That is incorrect.
Okay. So what you're telling me is if I give you the opportunity, you'll be able to find for me billing entries that explain why it was necessary for more than one attorney to be at a hearing.
I can tell from the entry whether or not an additional lawyer was required at a specific hearing.
Let me echo what you just read. The applicant should explain the need for multiple attendees. Explain means in the billing statement, it should be explained why more than one lawyer attended, correct?
Not necessarily.
Where am I going wrong there?
It does not say that it should be in the fee statement.
Okay. Do you have explanations as to why? Certainly you would have them in email, why 2, 3, 4, 5 lawyers need to be present at a hearing?
It would be verbal.
Okay. When did that happen?
Most hearings,
And they explain to you why they're billing multiple lawyers at those hearings.
yes, I understand in advance the need.
And so you would agree with me that from reading the fee applications, we wouldn't know that, correct?
Possibly so.
Definitely so. And you would agree with me that the U.S. trustee wouldn't know that, correct?
Yes,
You would agree with me that the committee lawyers wouldn't know why multiple lawyers had to be at a hearing, right?
yes,
And you would agree with me that Judge Grable wouldn't know why multiple lawyers appeared at a hearing.
I would not agree because I don't know Judge Grable's position.
Okay, but what I'm telling you is if she's reviewing what we're reviewing, and she doesn't have access to your verbal communications with Jones Walker, and let me ask, because you bring up an important point, they would bill for those conversations, correct?
Excuse me, who's they and what conversation?
Jones Walker would bill for telling you why they needed more than one lawyer at a hearing.
I can't, I would assume that they would, yes, sir.
And it would be evident by the billing statements, correct? Explain to Mr. Eagan why multiple lawyers were needed at a hearing.
Not necessarily in those words.
Have you seen any entry that would indicate a communication with you about why more than one lawyer was necessary at a hearing?
I cannot recall.
Would you also agree with me that these guidelines are intended to lower the cost for co-counsel for certain tasks?
I would imagine.
And we looked at this earlier, and I think you agreed that vague descriptions of work are to be avoided.
The vague description should be avoided.
Yes. You agree with that, correct?
Yes, sir.
Okay. And you would agree that it is important that the billing entry contains sufficient information to identify the purpose of the work or the benefit to the estate, correct?
Yes.
And that phrases like review file or talk to client without more detail are insufficient.
Could be improved, yes.
Well, I'm asking you with respect to what we've looked at and what we're looking at, not can they be improved, but those types of entries where you can't really figure out what's going on are insufficient entries, correct?
Typically, yes.
All right. I want you to take a look, if you would, on the right-hand column, going back to page 36-251. And if you go to the right-hand column, about a third of the way down, subsection K. Let me know if you see that.
I do.
And it says, for each professional and paraprofessional who billed on the matter during the application period. You see that part?
Yes.
And then you go down to Roman numeral number 9. Do you see that?
I do.
Do Jones-Walker's fee applications contain the number of rate increases since the inception of this case?
No.
Okay. They're supposed to, aren't they? According to these guidelines.
I have not seen them on any of the professionals.
And that's why I'm asking you.
Yes.
And so you would agree with me that that should be included on every fee application.
Objection to the form of the question. Answer if you can.
I don't understand the legal requirements within this document, so therefore I can't answer that question.
Well, I'm not asking you for a legal opinion. I'm just asking you if the number of rate increases since the inception appears on any of Jones-Walker fee applications.
They do not.
All right. And then if you go down to section L, which is the next paragraph, do you see that?
I'm struggling. Is that a 1 or an L? Let me see.
It's after Roman numeral 9. It's an L.
Okay, I see. Okay.
And it says, and I quote, if the applicant has increased rates during the case, the application should disclose the effect of the rate increases. For comparison purposes, the applicant should calculate and disclose the total compensation sought in the fee application using the rates originally disclosed in the retention application. Did I read that correctly?
You did?
Does Jones-Walker do that?
There is, as I recall, there's an entry for the discounted amount. I'm not sure if it was Jones-Walker, so I can't answer that question.
So my question is, Jones-Walker has gotten rate increases during this bankruptcy, correct?
As I recall, 1.
Okay. And have you ever seen subsequent to that rate increase on any fee application this analysis that I just read to you here?
No.
In fact, the effect of these rate increases as spelled out in these guidelines is not addressed in any Jones-Walker fee application that you're aware of, correct?
I agree with you.
All right. Do you understand what blended hourly rates are, Mr. Eagan?
I assume I could understand that. For instance,
Maybe
travel.
Go ahead, I'm sorry.
No, you go ahead.
No, you said travel, like...
Is built at a different rate than the hourly rate, so that's a blended number.
All right. That's your understanding of what blended rates are?
Could be, yes.
Now, I want you to take a look at page 3652, please. And if you go down to Roman numeral 4, let me know when you're there.
What column?
Left-hand column.
Okay.
And I want to talk about section 4, subsection A. It says, and I quote, "In calculating the blended hourly rate, section A, full service law firms should generally exclude all bankruptcy engagements or all data from timekeepers practicing primarily in a bankruptcy group or section." Did I read that correct?
You did?
Does Jones-Walker do this, to your knowledge?
I cannot answer that question.
Now, I want you to move to the middle column. Down to number 5. Let me know when you're there.
Is there any sub-paragraph that you want me to look at under 5?
Yeah.
Or the whole thing?
Yeah. So the questions that are supposed to be in the statement from the applicant, as you're looking at these, is it your belief that Jones-Walker follows these guidelines on answering these particular questions?
I do not.
If you go down to section B, it says, and I quote, "If the fees sought in this fee application as compared to the fees budgeted for the time period covered by this fee application are higher by 10% or more, did you discuss the reasons for the variation with the client?" Does a statement to that effect exist in any of Jones-Walker fee applications?
I do not recall seeing that.
All right. I'm going to ask you to go to the right-hand column.
Hold 1 second.
Let me know if you need a break.
No, I just, every once in a while I have to. I'm sorry. Go, where?
To the right-hand column.
In there?
All right. And it says
Which section, sir?
in section F,
So 5F?
yes. If the fee application includes any rate increases since retention, did your client review and approve those rate increases in advance? And you did that, correct?
I did.
Did your client agree when retaining the law firm to accept all future rate increases? Did you do that?
Yes.
Is that information included in any of Jones Walker fee applications?
I cannot recall. I do not recall.
When you negotiated these fees with the compensation scheme with Jones Walker, did they inform you that you need not agree to any modification in rates?
Object to the form of the question also calls for attorney-client privilege.
Attorney-client privilege on that, sir.
Certainly, there is nothing in any of the fee applications, including the 11th fee application, which states that you were informed, but you need not have been told that you did not have to agree to any increase or modification of rates.
Rephrase your question.
Sure, that information doesn't appear in any of Jones Walker fee applications.
Correct, yes.
All right. I'm going to ask you to go to the next page, please.
53.
Yes, sir. And if you go down to number 8, project categories for billing records, and it says to facilitate effective review of the application, all time and service entries should be arranged by project categories. Has that been done?
Yes.
All right. How is that done?
It's in the fee statements.
Let's go to the next page, please. And if you go down to number 11, case status in the fee application,
11. Yes, sir.
it says the following information should be provided to the extent possible. And then in B, it says the amount of cash on hand or on deposit, the amount and nature of accrued unpaid administrative expenses, and the amount of unencumbered funds in the estate. Is that disclosed?
In the monthly operating reports.
But not in the fee application, correct?
Correct.
All right, now if you go to the next page, 55, and I want to talk to you about Jones Walker's application for employment. So if you go to section 2, a verified statement from the client.
Wait, excuse me. Okay, I'm sorry. Go ahead.
Okay. Verified statement from the client. The client should provide a verified statement with all applications for employment filed under sections 327 and 1103 of the code that addresses, and we'll get to the following. Do you know if that was done here?
I believe it was, but I don't recall.
Do you know who would have signed that verification?
Be Father Patrick Carr.
If you go down to subsection B, you would expect to see part of that statement say that the steps taken by the client to ensure that the applicant's billing rates and material terms for the engagement are comparable to the applicant's billing rates and terms for other non-bankruptcy engagements and to the billing rates and terms of other comparably skilled professionals. You would expect to see that statement from Father Carr in the application for employment, correct?
I don't recall, but I would imagine.
All right. If you go to the next one, which is subparagraph C, It says the number of firms the client interviewed. Did you see that?
Yes, I do.
How many firms did the Archdiocese interview to represent it in this bankruptcy?
Jones Walker was the only firm we interviewed.
And that statement should be in the verification that Father Carr signed for the application for
I can't
employment.
answer that,
But it should be, correct?
I guess.
All right. Now, if you go to subsection D, it says, and I quote, "If the billing rates are not comparable to the applicant's billing rates for other non-bankruptcy engagements and to the billing rates of other comparably skilled professionals, the circumstances warranting the retention of that firm." So, are you aware if there's any such statement in a verified statement from Father Carr, or anybody else to that effect?
I can't answer that question. I don't know.
And if you go down to subpart E, in the first sentence of subpart E, that verified statement is to include the procedures the client has established to supervise the applicant's fees and expenses and to manage costs. You see that?
I do?
That is a very good recommendation, is it not?
Yes.
Okay. And that should have been included at the very beginning of this case in the verified statement from Father Carr or whoever else would have signed it, correct?
I do not know whether it was or not.
If you go down further in subsection E, you see where it says "in addition"?
Subsection E, in addition. Yes, at the end.
It says, and I quote, "In addition, describe any efforts to negotiate rates, including rates for routine matters, or in the alternative, to delegate such matters to less expensive counsel." Did I read that correctly?
You did.
And that's a really good guideline, isn't it?
Yes.
Right. And so you are unaware of whether Father Carr or anybody else signed a verified statement with that information in it, correct?
That is correct.
And if you look at the next one, which is subsection F, it says, and I quote, "The client verification should be appropriately detailed and should not be a routine form prepared by the client's bankruptcy counsel," correct?
Yes.
Okay, and I would agree with you that this might exist. I haven't seen it, and you haven't seen it, correct?
That is correct.
All right. Do you know what efficiency counsel is?
Not specifically.
You know what conflict counsel is?
Yes.
Does Jones Walker have any conflict counsel in this bankruptcy?
Not that I recall that was billed.
Okay. Do they have any conflict counsel that wasn't billed?
I can't answer that.
Now I want you to take a look if you go to the middle column, and it would be section 1C.
What page are you on?
Wait.
I'm on page 36-256, middle column.
Okay. I'm on the wrong page. I'm sorry. Middle column,
Yes, sir.
3,
It's actually C down in the middle.
3C, okay.
And just let me know when you finish reading that paragraph.
I'm going to reread it. I've read it.
There was a settlement negotiated with TMI in this case, correct?
There was an agreement made with TMI based upon cash collateral, yes.
Okay. Who negotiated that on behalf of the Archdiocese?
It was, the negotiating parties were outside counsel that is a bond counsel who is not associated with Jones Walker, along with Lisa Futrell at Jones Walker,
Okay.
under an agreement with me based upon the final document.
Is there a conflict waiver?
I don't recall.
The last thing I want to talk to you about on this document, Mr. Eagan, if you would go to the right-hand column on that page, which is 36-256, section G.
Which number, sir?
It's section G right
Yeah,
here.
you want me to read the whole thing? There's numbers underneath it.
Yeah, let's go through read number 1, and I have some questions for
Okay.
you about that.
Out loud or just to
You
myself?
read it to yourself,
I'm
please.
sorry. What page are we on? I'm sorry.
56.
56.
All right.
Right column, G1. I've read it.
Prior to today, were you aware of the availability of any of these special fee review entities?
You asked about a fee auditor before. I'm aware of a fee review organization that could look at fees.
Okay, well, did you know that these guidelines, well, I'm guessing you didn't because you didn't know these guidelines existed, but did you know that in bankruptcy there's an availability with respect to reviewing fees of a fee review committee with an independent member and an independent fee examiner?
I was not aware of that.
If you look at, I want you to take a look at page 36, 257. In the middle column down in section C.
I've read it, yes, sir.
Would you agree with me that an independent fee examiner relative to all of the fees in this case would be a very good idea?
Not necessarily.
Why not?
It's a multifaceted question, and I've reviewed that with counsel, which I would ask for attorney-client privilege on that.
I don't want you to tell me anything that you've spoken with the attorneys about. I'm just asking you as the corporate rep on this issue, for whatever reason, these fees are as high as they are. And I think we all have our positions on that, right?
We do.
You wouldn't agree with me that it would be a good idea to have somebody independent reviewing Pachulski Stang, Locke Lord, Jones Walker, all of these fees. That would be a good idea, wouldn't it?
I would disagree. I reviewed that myself and have come to the conclusion that I do not want to do that and would not recommend that. Can we take a bathroom break? I'll be right back.
Sure, yeah.
No.
Yeah.